Good morning, and thank you for joining me on the webinar. My name is Philip Kruger. I'm a director in the legal department at RSM South Africa, and together with my colleague Thilin Pillay, we're going to be looking at data privacy today, and then specifically looking at the POPI Act, or the Protection of Personal Information Act. So just having a quick look at what my portion of the presentation will cover today and what we're going to be focusing on. Firstly, we're going to have a brief look at the role players within a data privacy scenario. We're going to have a brief look at what personal information is. Then we're going to be looking at when POPI does not apply. And then we're going to be looking at the grounds for processing. And we're going to have a bit more of a focus on consent. I think probably consent is the most important ground for processing. But as we'll see, it's certainly not the only ground for processing. And then we're going to have a quick look at the RSM SA compliance pack. So it's going to be what our sort of suggested approach towards implementing policy would be around. And then we're going to have a quick look at what to expect going forward and what we see happening going forward. Before we get into it, just in brief, we're going to go through some of the latest news. And I think we should start off by saying that we're not sure how the latest developments or the recent developments around COVID-19 will affect the proposed commencement date. And we're not entirely sure whether it will affect it at all. It all just really depends on where government's focus is going to be within the next couple of weeks. But as far as the sort of latest confirmed news is concerned, the Information Regulator has recently made statements about the commencement date of POPI, and she has requested the President to proclaim a commencement date. And that seems likely then to be the 1st of April 2020, which is already upon us. Barring the recent developments around COVID-19, there doesn't seem to be any other good reason why this will not happen. So as far as we're concerned, we are still expecting it to be 1 April 2020, but we'll keep a keen eye on that. If it is indeed 1 April 2020 that the commencement date will be effective, it means the effective date of POPI will effectively then be 1 April 2020. The legislation does allow for a 12-month grace period ending on 1 April 2021. And really the 1-year grace period is to get your policies and procedure in place. However, as you will see as we go along through this presentation, 12 months only provides very limited relief to get this done. There's a lot that needs to be done, and 12 months is actually not really that much if you look at it holistically. Effectively, then we make mention there of the fact that POPI will only be in force 8 years after it was enacted in 2013. And in my mind, it really goes to show how sensitive matters around data privacy is. This is not just a simple piece of legislation. It's not the world's longest act, but it's quite complex and it's quite tricky. And I think it's going to really impact the way that we do business. Then looking at the most likely role players in any POPI scenario, at the very top there, we have the data subject, and then that's really the most obvious one. That's the person whose information is being processed, and most likely also the person from whom the information is indeed then collected. Right below the data subject, we have the responsible party. Now, this is defined to be the organization or person who determines the purpose of or the means of processing of the information. What is important to note there is that your responsible party will always remain liable. From a legal perspective, the buck in terms of liability stops with the responsible party. So it doesn't matter whether that responsible party will then forward on that information to a third-party supplier or who else deals with that information. The person who the claim will be brought against by the data subject will be the responsible party, and the person who will be held accountable by the regulator will also be and remain the responsible party. Then just to the right of it, we have an insertion there called the information officer. Now, the information officer is a requirement as per the POPI Act. Every responsible party has to appoint what is called an information officer. Now, this will by default be the head of a private body, so your CEO or your MD, but it can be delegated. And usually when you say it can be delegated to clients, their eyes sort of light up, because the more we can sort of move off our plate, the better. But what is important is you can't just delegate this function to anybody within the organization. It has to be someone of a certain level of authority. The reason why I say this is, if you look at what your information officer is supposed to be doing, it has to be someone who would have the ability to influence policy. So what his responsibilities would be is he has to ensure compliance with the POPI Act. He has to be able to influence policy and decision-making around the implementation of the Act. And he has to interact with the regulator, as well as receiving and evaluating requests in terms of the POPI Act. So as you can see there, it certainly can't be sort of your lowest level of responsibility individual in your organization. It has to be someone with some seniority and authority. Then just below there, between the regulator and the responsible party, we inserted what's called a data processor, or as it is more well known these days, an operator. So essentially what this is it's a third-party processor. So essentially it would, for instance, be a cloud provider, or for instance, someone who you would refer your credit checks and your sort of history checks to, etc., etc. What is essential is that if this data processor or operator processes information on behalf of the responsible party, as we said, remains liable in the eyes of the law. It is then also a requirement of the POPI Act that there must be a written agreement between the responsible party and this third-party processor. And this written agreement must then ensure and require that there are proper safeguards in place that such data processor or operator is implementing in order to process the information and indeed to keep it safe. However, as we said, even though that will be in the agreement, the responsibility remains with the responsible party. And therefore, it's very important from a legal perspective to have proper indemnity clauses in those written agreements. You have to ensure that you're able to say, in terms of your contractual relationship with this third-party processor, that yes, I as a responsible party will be liable towards the data subject and towards the regulator in essence, but in the event that I do have claims against me and I have to make good on those claims towards the data subject because of your negligence, I will have a contractual recourse against you. So very important to look at those indemnity clauses. Then our last party or role player here is the regulator. Now, the regulator's offices we know will be headed up by Advocate Panzi Tlakula. She's very, very experienced. And then essentially the office of the regulator will be tasked with monitoring and enforcing compliance with the Protection of Personal Information Act. And in this regard, they have very wide powers. It's indeed very broad. They have search and seizure authority. They can call witnesses. They can call upon any documents. It's really quite wide in terms of what they can do and in terms of the investigation powers. And then, of course, they can provide you with fines in terms of the POPI Act as well. So against that background, let's look at, just in brief, at what personal information is. So firstly, it's information relating to an identifiable living natural person. So in other words, a warm body, as they say colloquially, or, and this is the interesting one, an existing heuristic person as far as applicable. Why this is interesting is because it's particular and quite unique to POPI. It's not found in the GDPR, and it's not found often in data privacy legislation around the globe. It's going to be interesting to see to what extent you could identify sort of personal information when it comes to a company and a CC and sort of heuristic entities. And we'll have to see how this plays out. Certainly does make POPI more onerous and a little bit more complex than a lot of the other data privacy legislation. And it's going to be interesting to see how they interpret those provisions to work around that. Then essentially going through what the examples of personal information would be, it would be information relating to your gender, race, sex, pregnancy, marital status, national, ethnic, or social origin, color, sexual orientation, age, physical or mental health and well-being, disability, religion, conscience, belief, culture, and birth. And you'll see there that some of these grounds that I have highlighted there are in red. Whenever you see those words highlighted in red, that means that the information relating to that particular topic or subject matter would be deemed to be special personal information. Special personal information is then dealt with in terms of Section 26 and Section 27 of the POPI Act. And really, essentially, there's a general prohibition against processing information relating to special personal information. That general prohibition, however, can be overcome by having the following grounds for processing. Firstly, you could process it if you have the consent of the data subject. As I said, we'll look at consent quite closely. Secondly, if there's a right or obligation in terms of law to process this special personal information. If there's an obligation in respect of international public law. Fourthly, then, if the information has been deliberately made public by the data subject. Interesting there, the usage of the word deliberately. So in other words, if it is a leak and it is in the public domain and it wasn't deliberately made public by the data subject, that wouldn't actually be sufficient under this ground. And then lastly and fifthly, processing for historical, statistical, or research purposes. Then looking further at what personal information is, education or medical, financial, criminal, and employment history. Criminal history there again being a special personal information ground. And then this next one is quite broad, and it usually does just indicate how widely applicable POPI is. Personal information would also then be any identifying number, symbol, email address, physical address, telephone number, location information, online identifier, or other particulars assigned to a person. So if you think about your day-to-day business, if you think about receiving CVs, if you think about receiving emails, contact details of individuals, some of this could certainly be personal information, and you would have to ensure that you have the proper grounds to actually process that information. The next one, the use of biometric information. Biometric information, again, being a special personal information ground, and therefore consent, in my mind, being quite essential in those instances. What is interesting about biometric information is it has a very technical definition in the Act as to what constitutes biometric information. I'm not going to read through it now, but essentially what has been mentioned by most industry experts is that biometric information would also include the use of photographs. So where you are going to be processing photographs, in my mind, it's essential to have the proper consent in place beforehand. Then looking at personal opinions, views, or preferences, the views or opinions of another individual about the data subject, correspondence sent by the data subject that is implicitly or explicitly of a private or confidential nature. There, particularly if you think about things as elementary as settlement agreements, that would definitely relate to personal information. And then here, the last ground we have here, the name of a person, if it appears with other personal information relating to that person, or if the disclosure of the name itself would reveal information about the person. And it's here where POPI brings in this sort of a linking element, where the name of a person itself wouldn't necessarily just be deemed to be personal information, but if it links to any other information. So, for instance, a name and a designation, or a name and a physical address, a name and an ID number, that combined would then certainly constitute personal information. So what is important to note here is how incredibly wide the definition of personal information is. You can hardly think of examples that wouldn't be personal information. And particularly if you think of things such as CCTV footage at your premises, that would be personal information. And you would have to have proper grounds to process that personal information. And we'll get into that a little bit later on when we look at consent as well. But CVs that you receive, employee information, all of that would be hugely sensitive, private, personal information. And you'd have to ensure that you think about what you are going to have in place in order to process this information beforehand. So then quite often it's easier to say, well, when does POPI not apply? So POPI doesn't regulate pure or household or personal activities, pure household or personal activities. So it's not entirely clear what that means yet. There's no definition in the Act as to what pure household or personal activities would be. We hope that it will become a little bit clearer as the Act is implemented, and there's interpretational notes that will be made available from the regulator side. But what is clear is that it would fall outside of the commercial sphere. So anything that is purely domestic or maybe for administrative purposes could potentially fall there, but making sure then that it's not of a commercial nature. Secondly, looking at information that has been de-identified. When we're talking about information that has been de-identified, it's important that that information will not be able to be linked to a person, and that no amount of re-engineering or reprocessing would be able to link it to a living identifiable person or heuristic person. Then information processed by or on behalf of a public body. Typically there we're looking at national security, defense or public safety, investigation, prevention or proof of an offense. And then importantly, if you look at the courts, prosecution and execution of sentences, of course, has to fall within there. You can't really limit that function. And then lastly, processing for purely journalistic purposes if subject to a code of ethics. So really what it's saying there is that for journalistic purposes, the legislator recognizes and identifies that journalism is quite tightly regulated in the country, and therefore it's not necessary that POPI provides protection, as adequate protection is already in place there. Then looking at when you can process personal information. So particularly then looking at Section 11 of POPI, and it provides you with the grounds upon which you can base processing personal information on. The first one being consent of the data subject. As I said there, I think that's the most important one, but certainly not the only one. Consent, we'll see, must be specifically obtained, and there has to be certain requirements. It's not just consent in the ordinary course, but we'll go through that. Secondly, if it is necessary for the conclusion or performance in terms of a contract to which the data subject is a party. The example I always use there is an employment agreement. Intrinsic to an employment relationship and concluding an employment agreement would be the processing of certain personal information. And therefore, it cannot be said that you should be prohibited from doing that if it would be prohibiting you from performing in terms of contract. Thirdly, an obligation imposed by law on the responsible party. A good example would be your FICA requirements, and the law would always trump whatever mechanisms are in place there. In order to protect the legitimate interest of a data subject, there, as an example, I always use quite a rudimentary example, but I think it brings the point across. For instance, if you're on a car crash, if you are in a car crash and you are so injured that you cannot provide consent to this paramedic who's frantically looking through your wallet trying to find out who you are, obviously you have a legitimate interest to be taken to hospital and to be provided care, and therefore obviously you should be able to process your personal information at that point in time. So yeah, quite a simple example, but I think it illustrates the point. And then if it is necessary for the proper performance of public law or a public law duty by a public body, a good example there again would be the courts. Obviously the administrative function of state needs to still keep on ticking over. And then lastly, if it's necessary to pursue the legitimate interests of a responsible party or the interests of a third party to whom the information is supplied. But the grounds, it's a responsible party bears in respect of all of these. So you have to prove or be able to prove that one of these grounds were present in order for you to have processed the personal information of a data subject. Then looking more closely at consent, again, I've said this before, in my view, the most important ground. I think it's the one that we'll end up using the most, purely because we can sort of aim and direct it by drafting the clause properly. But having said that, you don't forget the other grounds in terms of Section 11. Whenever you cannot get consent or where it isn't practical to get consent, you can always base processing on one of those other grounds if you can find one under which you can fit the particular processing that's taking place. Looking at consent then, Section 11(1) of the POPI Act. And again, I make note there, it's arguably the most important ground. In the case of a minor, in the case of a child, that automatically will be special personal information, and you need to get consent there. You have to have that sort of higher threshold. But importantly, you'd have to get the consent of what is deemed to be a competent person related to that child or minor in order to consent to the personal information. In all likelihood, that will generally be the legal guardian of the minor child, bearing in mind that where there isn't a legal guardian, the High Court is the uppermost guardian of all minors or children, so they would always be able to consent in that regard as well. Then looking at what the Act requires from consent, it specifically states three things. It must be voluntary, must be specific, and it must be informed. If we're looking at voluntary, in other words, it cannot be implied or coerced. Specific, it must be clear and unambiguous. Informed, here it is important that we look at the plain language movement. It is essential that the data subject understands what he or she is consenting to, and that it is an informed decision that they are making. So then looking more closely at what is required when we understand the concept of consent. Consent cannot be implied. It calls for an explicit expression of will. So what does this term explicit expression of will means? Well, we can look for guidance there to the GDPR. The GDPR issued a notice explaining this concept of explicit expression of will. And really the first thing you need to know there is it's a clear affirmative act. Secondly, it could include ticking of a box. So all of these forms that you see that says, do you consent to me processing your information? And you have to actually physically tick that box. That would be approved by the GDPR, and most likely in terms of POPI as well as in terms of providing consent. What it cannot be is it can't be silence, can't be pre-ticked boxes, and inactivity will not constitute consent. So that raises the question, where does it leave the so-called opt-out approach? So in other words, that approach where it says, unless you go to this website and you opt out, we can process your information. In my view, opt-out is not sufficient. I think it is quite clear in terms of the GDPR guidance that it must be a clear and affirmative act, and that silence or inactivity cannot constitute ongoing consent. So in my view, opt-out is not an approach that can be followed. It must be specific, so in other words, it must be quite clear as to what personal information will be processed and what will happen to that personal information. Will there be further processing involved, etc., etc. And then lastly, it must be informed. And there are flagged language issues from a South African context that will be very challenging. If you think about it quite carefully, we have 11 official languages. And within our sort of social environment, the level of understanding of language isn't always the same. So really the only remedy for that is using as plain a possible language in your consent clauses as possible. Do not use legalese. Don't draft it in sort of a lofty, higher level English. Draft it as plain and basic as you possibly can. And that's really your only remedy, short of having a consent clause available in all official languages. So draft it in plain, clear to understand English. Then looking at what a good consent clause would contain if you draft it properly. It must be an explicit declaration of consent. So in other words, what is processed, how long will it be retained, and will there be further processing involved? You have to have the details of notification requirements in there. In other words, a clear expression as to what will happen in the event of a breach of your personal information. Transborder transfers, you have to be express in terms of saying whether there will be transborder flows of this personal information or not, and if so, to where. Record retention, you have to indicate how long you will be retaining records, when it will be destroyed, and how it will be safeguarded. Further use, whether you will be forwarding this information to any third parties or third-party processors, and of course, direct marketing requirements. And my next slide is going to focus a little bit more on direct marketing requirements, because the Act has very specific requirements in terms of direct marketing. There we look at Section 69 of the POPI Act, and it applies to all SMSs, MMSs, email, voice messages, automated calling machines, telemarketing, pamphlets, and after all of those electronic means, in-person approaches as well. What is important is if you are going to be doing direct marketing, you can only contact a person that has not withheld their consent before. If that person has, in a prior instance, indicated they do not consent to having their personal information processed, you cannot process that information, and you cannot indeed even contact that person any further. And then important too, that basically also flows to the next point, you can only contact them once. If they refuse, you can't contact them again. You only have one stab at it. There is a prescribed form that can be obtained within the regulations of the POPI Act. It's called Form 4. What is important to note there is you can deviate from Form 4. Form 4 is a very sort of typical regulatory form. It's very draconian. It's quite bland and definitely not a marketer's dream. So you can deviate from it, but what is essential is that the elements, the substance of Form 4 must be retained. So if Form 4, for instance, has a block that you have to tick, you have to retain that block that needs to be ticked. If it requires you to provide your address and the name of the information officer, you have to include those details into your format that you are going to be using. So the substance of Form 4 needs to be retained. And then lastly, when we're looking at direct marketing, you can only do it to a customer. So in other words, you have to have obtained the contact details during the course of a sale or the provision of a service, for instance. If you are going to be contacting them with further direct marketing, it has to relate to similar products or services, and the data subject needs to be able to object to having their personal information processed when consent is obtained initially, and with every communication thereafter. For the communications thereafter, there I think an opt-out provision might be appropriate, but certainly when you are looking at the initial consent obtained, opt-out isn't appropriate there. Moving on to what RSM South Africa would suggest should be in a compliance pack, and certainly what our product to market will certainly also include. Firstly, what we would suggest there, first and foremost, is to update your POPIA manual. Your POPIA manual has to be amended by having particular insertions relating to the POPI Act and being quite specific as to the information that you do process there. Secondly, a comprehensive data protection policy would have to be included. And there we're looking at both internal and your external environment. Specifically internal, because I think to a large degree, internal threats are quite often the most prevalent threats from a POPI perspective. The likelihood of information leaving your organization through an employee unwittingly providing it is far more likely than a external breach. Model clauses for contracts, particularly then looking at things such as employment agreements, consent clauses that are properly drafted, as well as your third-party processor or operator clauses, essential to look at those agreements. Personal information sharing policy, that'll include your access requests, as well as any information relating to trans-border transfers and what should happen in those events. Website and privacy policies, particularly looking at cookies there. It's a really nice technical measure that we all use in order to gather information, but the processing of that information quite often leads to the processing of personal information, and therefore quite important to address your cookies policy within your website privacy policy properly. Security compromises policy. It's only fair that you have to have quite a detailed policy in terms of what happens if there is a breach. You have to be able to provide both the data subject as well as your employees with guidance as to what happens when a breach takes place and what sort of protocol will be followed. A proper data retention policy. In other words, how long will you be retaining information for? How long is reasonable for you to retain that information? And where will it be retained? What type of security will be in place? All of those things need to be addressed. Bring your own device policy. You can imagine bringing your own device to an employer. That is one of your biggest risks from a POPI point of view. Then also looking at CCTV and photographic images policy. CCTV particularly important there. I mean, there are a lot of grounds that you can base CCTV footage at your offices on. You can say you have a legitimate interest to protect your property. You can say that it is within the interest of the data subject that you are having CCTV there. For instance, if someone bashes into their car. But to me, probably the right way to go about CCTV footage would be to have a proper consent on your building and around your building in order to ensure that individuals entering your premises consent properly and indeed provide an informed consent as to CCTV footage. Then lastly, also information officer appointment letter, making sure that individual knows what is expected of them, what is the terms of their employment, and sort of what their rights and obligations would be in that regard. And then, of course, a proper password policy. Lastly, then, from my side, looking at where we are now and what we can expect, at the moment, I think we're all waiting with bated breath for the confirmation of the commencement date, particularly because it is so close upon us. As I said, we'll have to see what impact, if any, COVID-19 and the sort of disaster around that would have on this. Then sector codes for industry, we are expecting that to come out shortly after the commencement date. Certainly, I think the medical and insurance industries would definitely be looking at adopting sector codes, just sort of making the application of POPI fit for purpose within that industry. And then just to mention again, looking at the 12-month period to implement policy and practical measures, it's really not a lot. Even if you just look at the policies that we've looked at now already, in order to ensure that those policies are fit for your business and sort of applicable to your business and properly running by the time POPI is enforced, 12 months is not a long time. And then lastly, we would hope to see some guidelines coming from the regulator in terms of the practical and interpretational issues around POPI. And with that, that is my portion of the presentation, and I'm going to be handing over to my colleague, Phil Pillay, to take you through some industry-specific case studies relating to POPI.
Thank you, Phil. As Phil indicated, so I'm Phil Pillay. I'm a director in the Risk Advisory Department at RSM, with a specific focus on technology risk leading into our service line and solution set around security and data privacy. We've actually worked on many clients in quite a few industries, and I thought that it would actually be quite informative to present some of those case studies from in 3 industries: consumer goods, private equity, as well as from in the education sector. And what has come out of the gap analyses that we have actually performed for some of our clients in these particular industries. You will see that whilst we go through these particular case studies, that there are some overlapping and consistent findings that we have actually identified. And this actually just does talk to the challenges that is being experienced by organizations and that's going to be experienced by organizations in the implementation of POPI, as well as their roadmap and their timeline to compliance. So let's look at the consumer goods industry. Now, the consumer goods industry will also encompass things like your businesses that operate maybe on an e-commerce platform. It will look at things that businesses that operate on a referral basis, where they sell, door-to-door sort of marketing. I mean, there's a lot of cosmetics companies that operate on this particular commercial model as well. What we found from a consumer goods aspect is that the actual consumer PI, and this is more specifically now to the target market of the particular organization, was far greater than what the actual company was aware of. And this talks to the knowledge from a top-down back down to an individual staff member processing personal information. And there's quite a bit of a knowledge gap there between the senior stakeholders and senior management versus the information that is actually being processed on the ground to the actual consumers. And there was quite a big gap there. The other aspect that we identified from the consumer goods industry was the vast amount of high risk SPI that was being processed. And this was actually without the knowledge of the company. And when I say that, I mean, I'm talking about sort of the senior stakeholders, senior management, individuals like your information officers or individuals with those particular responsibilities, or that, that would be in a liable role there. And it was not needed to actually support the commercial objectives. What it was maybe to obtain maybe some additional marketing insights. However, it was not actually made, the consumers at the time of obtaining that particular information was not made aware of the specific SPI. Now I'll give you an example of something that this could occur in. If you look at some marketing, consumer goods companies, when they obtain a lot of information for consumer insights, this is to be able to build their business models, build new product models, and be able to target those to the right demographic. Some companies, if you're looking at companies maybe in the cosmetics industry, that they would maybe be looking at developing profiles for some of their clientele. And this incorporates things like maybe utilizing their photographs on the particular consumer profiles. And as well as inferring certain demographics from information that a consumer may fill out on a questionnaire. They may not have explicitly indicated that I'm of a certain race, that I'm of a certain gender, etc. But if you were to infer that information and then put it onto a consumer profile and then distribute that consumer profile, that is going to constitute processing of SPI. So that's a very important thing to note there. They were not, the clientele that we have actually dealt with in this particular industry was actually not aware of that particular risk that they were exposing their business to in that regard. PI and as well as SPI was being transferred to data operators without the appropriate data protection requirements. Now, Philip mentioned earlier in terms of one of the key aspects and key things to consider is looking at clauses with regards to your data operator agreements. And this is actually of vital importance. When it comes to your data operators, you need to know that because the responsible party from a POPI aspect is really the ultimate responsible party and liable party for data breaches and for damages, you need to also then be able to hold your data operators to the same account and to the same data protection standard that you're going to hold yourself to. Because if you need to be able to identify a data breach of a data subject that you are processing information for, you cannot do that if your data operator does not have the same data protection mechanisms in place in order to actually notify you that a breach has occurred. This opens your risk profile and increases your risk profile from processing personal information, maybe from a low aspect where you might have thought of initially to actually quite a high risk aspect, because you don't really know what you are exposing yourself to. You don't know to what extent your operators comply with standard industry practice, standard best practice from a cybersecurity aspect, from a data protection aspect, from an IT risk management aspect. And also, just from a normal Companies Act compliance aspect, you actually don't know what their compliance levels are. So data operator agreements and service level agreements, when you actually build those clauses into those agreements, holds those data operators to the same standard that you're going to hold yourself to, and allows you to actually measure your risk appetite within a tolerable level. The fourth aspect then is around technical security safeguards. This is a sort of an overwhelming and overlapping aspect that we've identified from a gap in almost all industries. Most companies think that I have my IT department and they're taking care of my IT security. They're taking care of the security on our laptops. My emails are secure, but you are operating on an assumption, and this is really the gap that is overlapping across the industries, is that the companies are predominantly operating on assumption and not on fact in terms of what is actually taking place in their organization. They're not familiar with what the actual technical security safeguards that are required to be in place to prove to a regulator, should they pitch up at your door, that you have taken reasonable measures to ensure that the protection of a data subject's PI and SPI, to make sure that you've taken those reasonable measures to prevent as well as identify and mitigate a data breach should it occur of a data subject's PI and SPI. Philip spoke about earlier in terms of data protection policies. And this is key in terms of having a data protection policy from an internal aspect as well as an external aspect. But he did indicate that internal is actually quite critical. And this is because insider threat attack vectors are actually one of the highest attack vectors from a cybersecurity standpoint in terms of the breach of not just data, personal information in SPI, but as well as confidential information. And you are going to find a lot of overlapping between SPI, PI, and confidential information. And it's quite key to identify that in a discovery standpoint, which we'll talk about a little bit later on. The other aspect was direct marketing processes, and those required significant changes. They were not aware of the actual, the consent mechanisms that was being used from a direct marketing standpoint. Many companies, and you'll know it from a telemarketing standpoint, etc., they actually use pre-scripted questionnaires that when they pick up the phone and they call you, they're going to be asking you a specific set of questions. And if you were to reply no or reply yes, they've got an alternative question to ask you in response to that. And it's what we found is that those scripts for a client in a consumer goods industry that also operates in a direct marketing aspect, is that their scripts were not fit for purpose. Their scripts do not have the correct consent clauses. The scripts do not have the correct privacy notification clauses, because at this point you would actually you should be notifying the data subject of your collection mechanisms. This is why you're collecting their personal information. This is the type of personal information you're collecting. This is how it is going to be processed, and this is how it's going to be sort of safeguarded. Essentially, a privacy notice. So, I mean, most people would log onto any number of websites these days, and you will be presented with a pop-up regarding a privacy notice or a cookies notice, and you would be asked to read and accept that. A privacy notice, essentially from a direct marketing standpoint, needs to actually be put in place, because that is your first point of contact with your end consumer, with your client. And it's critical that those scripts are tailored and are fit for purpose for your business, and from a risk standpoint to be able to address your risk exposure. The other aspect on a consumer goods industry, and this is also applies to organizations that then operate in an e-commerce environment, actually more so, because their consumer audience and their consumer market operates across a wide range of geographies. What does this mean? It means that because your consumers operate in a wide range of geographies, you are thereby required to be compliant with the relevant data protection legislation in those geographies, such as the GDPR in the EU, such as the CCPA in California in the US. So one of the challenges that the organizations are experiencing, especially in consumer goods and in e-commerce environment, is that they're actually not aware of the multiple data protection legislation requirements that they are required to actually be compliant to. And this opens the organization up to actually significant risk, given that, especially from a GDPR standpoint, your penalties are far higher than that of a POPI standpoint. And if you're a multinational business with your holding company in one of those particular geographies that's not in SA, then it's going to be looking at the turnover of the company as a whole, and looking at being aware of what those multiple data protection legislation requirements are, and operating and developing a data protection standard for your organization that encompasses all of these different modalities is of critical importance. The next industry that we're going to look at is the tertiary education sector. This does also apply to your primary schooling level, your high school level, middle school, etc. But we've dealt with a lot of clients in the tertiary education space, and more specifically around the tech in the tech industry, where they are providing this type of training. And you would expect, maybe it's normal to maybe expect a company to maybe operating in a tech space to actually be quite well versed from a data protection standpoint. But there's an old adage, of the story of the shoemaker's children, and when it does apply as well to sort of tech companies. They don't really know what the level of personal information and special personal information that they're actually processing. They don't know the information, the SPI and API that is actually being collected by their staff at a very low processing level, but at the initiation point in terms of collecting PI and SPI. And the vast amount of PI and SPI that is being collected. Responsible persons were not assigned. This is a key and critical point in terms of project management and managing your data protection project in terms of compliance with POPI as well as GDPR. If you do not assign responsible persons to undertake this particular task, then you're going to wind up in a situation where essentially you've got multiple business units, multiple stakeholders in your organization, and each business unit does not know what the other one is doing. And this actually opens up the organization to a high risk of a data breach as well as non-compliance with POPI. Philip spoke about what we think is some of the critical policies from a compliance pack standpoint, and this is also one of the gap areas that we've identified across the board is critical compliance and mechanisms. Now, the thing to bear in mind here is that a policy is a standard. A policy is not, I'm taking what I'm doing currently and turning it into a policy. A policy is something that you need to operate as a best practice and legislative requirement standard against which you need to measure your organization against. And this needs to also be supported by appropriate and adequate mechanisms to be able to facilitate compliance to those policies. A key example there would be an incident management response policy. You could have that policy in place, but should you not have the correct mechanism, either be it via notification, via the right channels for a data subject to be able to come to you or report a data breach, or data breach to be reported internally, for it to be tracked and monitored. So those tools need to be implemented to be able to facilitate compliance to an incident management response policy. And key, that you need to be able to prove this, that you have actually put this in place, not just from a design aspect, but also from an operating effectively implementation aspect, should a regulator choose you for review once that 12-month transition period is actually up. Technical security safeguards. One of the key aspects and minimum things that is required is encryption protocols. And this is actually quite simple and quite basic, but a lot of companies are actually not doing this with regards to the protection of their PI and SPI. And this applies more so actually now when we are going into a COVID-19 work from home state, when we are going into working from a remote aspect. A lot of employees are working with PI and SPI on their laptops from their homes. What encryption protocols have we taken in place from an organization standpoint to make sure that those endpoint devices are actually protected should a particular data breach actually occur? Also talking to maybe BYOD protocols. Individuals, organizations may be requesting that the employees actually utilize their own devices for conducting business activities. In conducting those business activities, they're going to be processing PI and SPI of your clients, of your employees, etc. And this may not actually already be encompassed in your privacy notices. It may not be encompassed in your existing policies. And that's a key aspect to bear in mind, given the current state that the world and the current commercial environments are in right now. And another aspect which is quite critical is privacy training. There is no point in having a policy and not training your staff appropriately on that policy, because training is critical to implementation. And your training also needs to be fit for purpose. Training is not just on best practice, because you would train your IT staff on best practice. But should you develop and what you would need to develop a data protection policy, develop your privacy policies, your employees need to be trained on those policies, because you cannot facilitate implementation of those policies and implementation of the standard of that policy if the employees are not trained on those specific policies. So there is a distinction between just training on best practice from a data protection standpoint and making staff aware of what PI is and what SPI is and what the different channels of processing are, as opposed to also training them on your specific privacy policies. And then the third last sector that industry that I'd like to look at is private equity. And I think one of the key aspects here that I'm just going to talk about is just differentiating from the other two industries is the core for data protection compliance. And this was actually coming through investors in private equity. You have a number of investors in various private equity streams that operate in various geographies. And if you have, for example, an investor that's sitting in the EU, they're going to want to know, and they are asking for what protection requirements do you have for my personal information that I am now providing to you. You have, if you have various organizations, even in an SA standpoint, as well as parastatals, that are calling for POPI compliance because of the personal information that is now being transferred through to private equity fund managers in the processing and developing of the funds. And what we identified here is that the organizations were operating on an assumption, once again, that because they required the personal information to be able to be compliant with, from a FICA standpoint, that they were automatically absolved from the other 7 conditions of POPI. And this is a misnomer. You are not absolved from the other 7 processing conditions of POPI just because you have consent. Now, going back to what Philip indicated earlier, this is one of the areas, if you have to process the personal information for FICA compliance, this is one of the areas where you do have a legal basis for obtaining and processing that information. However, you still have to comply with the remaining 7 conditions of POPI, looking at things like accountability, looking at things like your safety and security safeguards around that information. You still need to be able to take the proper precautions in place from a data protection standpoint to prevent, as far as possible, a data breach of that PI even if you had a legal basis for collecting and processing that information. And then once again, the same gaps that we can see overlapping across the board, being the key business processes, business process owners and stakeholders are not aware, once again, of the PI and SPI that is being processed. Critical policies, you would expect, especially if you're processing information that is required from a FICA standpoint, you're actually getting a lot of personal information in that regard, as well as SPI. And one of the other areas that I would just like to talk about here is, and this stems across the board and is going to be very particular in an SA context, is BEE. From a BEE standpoint, when it comes to, and this is when it comes to processing your in-house employee information, you are going to be obtaining a lot of SPI, and this talks to race, demographic, etc. And you need to be able to protect that particular SPI and have that incorporated in your employee agreements, in your particular policy manuals, and in your data protection policies to make sure that your employees are aware of the personal information and specifically the SPI that is being processed. Now, a lot of companies do outsource certain BE activities to their other outsourced organizations. These organizations, such as service providers, will constitute operators as far as the primary responsible party is concerned. You need to ensure that those operators have the correct clauses in your SLAs with those operators to make sure that they have the right data protection mechanisms around that SPI, because you are going to be divulging SPI to them. So that is actually of critical importance, and that's one of the areas that we actually picked up across the board, across industries from an SA standpoint. So just with this in mind, I'd like to then go into some of the challenges that we've experienced quickly. And this is before we've come in to do a gap analysis. This is some of the challenges that clients have actually indicated to us. And that we've also identified is that, once again, the staff responsible for the POPI project was actually not well versed in the Act. Companies are assuming that they can actually maybe do it by themselves, but there's a lot of intricacies from a POPI standpoint, especially when you take into account the multiple data protection legislations that you also need to be well versed in. And you may be well versed from an IT aspect, but not well versed from a legal standpoint. You need a cross-collaborative effort and cross-knowledge pollination really there from those various aspects in order to properly manage a POPI project. The other aspect is the timeline to compliance. It was vastly underestimated because of, once again, the change in business processes that is going to be required from becoming POPI compliant. You cannot just assume that there's not going to be any changes to a business process. Generally, when you make a change to policy, and if the changes to policies are going to be quite significant, there are going to be significant changes to business processes, and those are quite underestimated, especially when they're doing their privacy impact assessments. And a lot of approaches that have actually been followed have been actually a tick box approach. You are doing yourself a disservice if you were to follow this approach. The best approach that we would actually suggest is a risk-based approach, because that means that you are actually developing a fit-for-purpose solution for your organization. If you follow a tick box approach, this is going to result in high costs and inefficiencies for your business, as well as the commercial objective of your businesses actually not being achieved. So you are going to put in a whole lot of requirements that sometimes actually don't even apply to your business. And it's not applicable. It's in instances that you are not actually processing information, and you are going to the cost and the inefficiencies come in. You're going to require a lot of additional monitoring of those aspects of the policies when it actually doesn't maybe necessarily apply to your business, or doesn't apply in the context that you thought it would. Training. A lot of organizations are putting in these standard tick box policies in place. And also not even training their staff on it. So staff is not even aware of what policies are in place. They're not aware of the clauses or the notifications they need to be making through to your organization's clientele. In the case of consumer goods, the end consumer. And lastly, but certainly not least, one of the major challenges is from a cybersecurity standpoint, and that's balancing risk as well as compliance. So now we're just going to go through the RSM solution quite briefly because we are running out of time. And our approach is in our security and privacy solution set is a multidisciplinary approach. We take a approach from our risk advisory standpoint, from a legal standpoint, and from an IT standpoint. And these three pillars allow us to actually address all of the aspects of a POPI compliance project and making sure that a solution is actually fit for purpose for your business. Our approach is split into four main areas, and that looks at mobilization, discovery, analysis, and reporting. As I said, we take a risk-based approach. We know where your gaps are and we prioritize them. You need to be, not all your gaps are going to get the same priority. And this is critical for you to know that you need to develop short and medium-term goals. And last but not least, your policies need to be fit for purpose. They need to meet the objectives and needs of your organization. From a mobilization standpoint, you're dealing with that's the critical first phase. And that's where we would define the scope, we would agree the plan, we would know what your resources you have and who in your organization is going to be dealing with your POPI project. It cannot, no matter who you choose, it cannot just be an outsourced service provider. Okay. Discovery is a critical phase. A lot of clients have said, I don't know what I don't know. And this is critical. This is, I mean, it's never been so true as it is maybe from a POPI standpoint. You don't know where your personal information is. You don't know what personal information you're processing. You don't know, to where I'm transferring your personal information. Discovery is a critical phase. You need to know, take a complete inventory of your personal information. Only then can you analyze it and then put in the right protocols to address it. Leading us into the analysis phase, which then looks at the analysis and evaluation of the discovery of the PI and the SPI from the discovery phase. When we look at the analysis phase, we do quite a critical analysis and benchmarking against the POPI requirements, as well as your risks of your entity and the needs of your entity, because that cannot be forsaken and you cannot just look at statutory compliance on its own. And that's where we come up with fit for purpose recommendations and solutions that we actually then go into our reporting stage, which then leads us to the reporting aspect, where you get a report which is a concise report dealing with the gaps and dealing with prioritized recommendations that addresses the needs of your business, but also addresses, but balances risk and compliance, cost and efficiencies of that. And yes, and then finally we have our roadmap to compliance, dealing with the various phases all the way from planning, awareness, and information asset register, which talks to the discovery phase. Once again, you need to know what you are processing. Your data protection officer requirement, from a POPI standpoint, that's going to be an information officer. They need to know what are their roles and responsibilities. This is a new phase for those types of individuals. And in a lot of companies, these are going to be roles that is going to be fulfilled by already existing individuals, such as maybe a CTO, or maybe somebody from an HR aspect, or maybe a legal counsel with an ICT specialization. Looking at privacy by design, and then looking at the individual rights. You need to know what are the rights, the individual's rights, in order to properly address your consent clauses and to properly modify your privacy notices and make those fit for purpose. Leading all the way up to your data breach, international, being your geographic locations that you're going to be processing personal information to, as well as cross-border transfer of information, and the review and activation then of the remediation solutions. And that is it from us. From Phil and myself, we'd like to just thank you for your time that you've given us today. If you have any questions on this webinar, as well, feel free to reach out to us at any point. We will get your questions that you have raised throughout the course of the webinar, and we will reach out to you directly and respond to those.